talking about it and freeing my mind. For others, is that I want to see the perpetrator in jail. For others, I just want to hear the perpetrator tell me I am sorry.
Good day, viewers. Welcome to today's episode of Justice for You. Thanks for joining us on our previous episodes. We hope it has been enlightening and educating. My name is Eunice from Edford Foundation, an organization that renders free legal services to indigent and innocent inmates here in Nigeria. And through the help of our team of lawyers, we're able to secure freedom for about 102 inmates in Nigeria. I have here with me today Miss Adetoro Lasisi. You're welcome.
Thank you very much.
Please, let's meet you.
Okay, my name is Adetoro Lasisi. I'm a legal practitioner and an associate with Legal Solicitors and Consultants, a corporate and commercial law firm, and we also do dispute resolution amongst other areas of law.
Alright, you're welcome.
Thank you very much.
So today we'll be discussing on all you need to know about police statement. Okay. Please, can you give us the meaning of a statement?
Okay. Generally, a statement could be a written or a video recorded account or narration of an event that has happened regards a crime. So I would like to start by stating or stipulating what the Police Act actually empowers the police to do with regards to investigation of crimes. So Section 4 of the Police Act empowers the Nigerian police to investigate crimes and in the process arrest and detain suspects in relation to any crime. So when a crime has been committed or when there is an allegation of a crime, the next thing usually is for the police to arrest with or without a warrant and detain certain persons who may be suspects. And upon the arrest, such persons may be questioned or interviewed, and in the process of questioning and interviewing or interrogating to discover or unravel who committed the offense, how the offense was committed, and what exactly is the nature of the offense. So something that needs to be done is a statement has to be written or taken down by the suspects.
Alright. So can you also tell us what a statement entails generally?
Okay. When talking about a statement, there are certain things, basic things that must be noted. First thing is, anyone who is invited to the police station to come and give a statement must first of all know his status. That is, he needs to know whether he's coming as a witness or coming as a suspect. Then secondly, we also need to understand the fact that you being invited to come as a suspect or to give a statement does not mean you're a criminal and should not be treated as a criminal. So basically, you need to know what exactly you're coming to the police station to do, whether to give a statement as a suspect or as a witness, and you also need to know the nature of the offense that is being alleged against you, and as well as the nature of the offense. Exactly. So apart from that, it is also important that you need to know your rights. I mean, certain rights are available to anyone who is being called upon to give a statement or make a statement. So it is also the duty of the police at the point of inviting you to make a statement, need to inform you about certain rights which are available to you. So first and foremost right which you must be informed about is the right to have a legal practitioner present at the point of making or giving a statement. Like we know, the Constitution also allows or guarantees right to legal representation. So also the Administration of Criminal Justice Act, I think Section 17, subsection 2, thereabout, actually stipulates that anyone who is invited to give a statement, or anyone at all, any person who is invited to give a statement or make a statement or arrested as a suspect must have his lawyer present at the point of making a statement, before he makes or writes any statement, or before he signs any statement at all. And if in case of you not having a legal practitioner present, you can as well make an application to the legal aid counsel to get a lawyer who would represent you, and as well as any lawyer from a civil society organization. So that right is something that cannot be derogated at all. Then similarly, you also have to be informed that you have the right to remain silent, and you have the right not to say anything at all or make any statement at all. Section 35, subsection 2 of the 1999 Constitution of the Federal Republic of Nigeria also guarantees that right, that you have a right to remain silent. You have a right to refuse to say anything at all until maybe you've conferred with your lawyer before making any statement at all. So also, I think section 6, subsection 2 of the Administration of Criminal Justice Act also supports what the Constitution provides in guaranteeing the fact that you can afford not to make a statement until your lawyer is present. And it is also very important that we know that the police has a responsibility of informing you that at the point of arrest or at the point of bringing you in for questioning, have a duty or a responsibility to inform you that you have a right to remain silent or not to make anything at all until you've actually seen your lawyer. Yeah.
Right. You defined the statement and you've told us what it's about. Can you explain how it is exactly in practice compared to what is written in theory?
Okay, that question is actually something that most of us can actually relate to, considering the conditions of our prison. In fact, I would like to even share a story of what a learned senior colleague shared with me about his client's ordeal while at the police station. So what actually happened was that the complainant, let's say Mr. AB, made a complaint to the police that he bought he made payment for a car from Mr. XY, that's the client. And the client refused to give him the car but collected the money. And he made a report to the police that someone had defrauded him, and the police went over to the car dealer's shop and arrested him. So the client had to actually spend the night over at the police station before his lawyer came in. And when the lawyer had to go see his client, the mistake the lawyer actually made was that instead of going directly to see his client first of all, he instead said he wanted to see the divisional police officer, that's the DPO. And when he got there, the DPO was trying to form familiarity with him that, I've heard so much about you, I know you so well. Lawyer, you're welcome. In fact, about that man's case, we've even made sure that he hasn't made any statement at all, because we know that it is important that his lawyer is present before he makes any statement at all. So the lawyer was kind of happy, so really we have good Nigerian policemen who are actually doing their work, discharging their work effectively. And so he said, okay, no problem, can I see my client? And the client was called into the room, and he noticed that the client just kept looking at the ceiling because there was a hanger and there was no fan there, but there was an hanger there, and he would look at the ceiling, then look at the eyes of the police officer. So the police officer was now interrogating and asking him, okay, now did you or did you not supply this card to Mr. XYZ? He would first of all look at the ceiling, look at the police officer, and then proffer an answer. So the lawyer was feeling uncomfortable with the kind of response he was getting and knew that there was something wrong somewhere. So he just had to, apply wisdom to it and pleaded with the police of the DPO to allow him speak with his client one-on-one and try to get him to say something before he makes his statement, and try to talk to him first of all. So the DPO was too reluctant to even allow him, but eventually he insisted that a constable would have to be present before he makes any statement or gives anything at all. So the lawyer also knew that if I allow this constable to stay, my client may still not be comfortable enough to tell me what actually happened or what transpired. So the lawyer then told the constable to help him get a biro, gave him 1,000 naira to get a biro. Then In process of going to get a barrel, he had ample time to ask and question his client. So in process of interrogating, the client now opened up to him what actually happened. That it wasn't that he defrauded this person or the complainant. What actually happened was that Mr. XYZ, the complainant, came to him saying he wanted to buy a car. And he showed him the cars that were available. He picked one, paid for it, and went away with the car and with the purchase receipt, only for him to come back like 2 days after, saying that that car had a problem with its AC and all, and he wanted another car. So he took the car that was returned, gave him another car that suited what he wanted and suited his choice, and he even gave him another purchase receipt for that new car which he took. Then few days later, before then, another person came to purchase that car which was earlier returned by the initial buyer. He saw it, he liked it, and he paid for it, and he even paid for it at a higher price and went with it, only for the initial buyer to come back saying that, I told my brother about it, and he said this car is actually, the initial car which I returned was actually okay, and I think I prefer that initial car which I actually bought from you, and I want my car back. Then the car dealer was like, the client here was like, no, there's no way I can return something you've already purchased. In fact, as a matter of fact, I've actually sold this car to another person, so I don't have any car to give you. Out of annoyance, he went away and made a report to the police saying that Mr. A defrauded him of his money, collected money from him without buying a car. So that was actually what transpired. But because of the pressure and because of the torture that had been meted out to the client here, Mr. AB, he was unable to state the true fact of what actually happened. And he was now narrating to the lawyer. The lawyer was now asking him out of annoyance that, why didn't you tell me? Why didn't you say this was what happened? Why did you have to lie against yourself? And he now said, Mr. Lawyer, do you see the ceiling over there? Can you see the anger that I had to stay there? In fact, I was on there for about 2 hours because the police wanted me to make a statement of what I actually did not do. And apart from that, if you know how terrible the police cells are, like no conducive environment, and actually the client was thinking of urine and feces, and plus mosquito bites, sleeping on cold bare floor, all of those things, would not want anyone who, even if you did not commit a crime, even if you're innocent, because of the pressure and because of the torture, the inhumane treatment over there, you would actually not want to spend another night there. So he said that was why he actually said what he said. So the lawyer now said, you know what, as a matter of fact, I'll make sure you don't say what you wanted to say initially. You will actually state the true fact of what happened. So he told the DPO that his client was no longer making that statement which he wanted him to make and all. And the DPO was angry, and I know that I'm going to make sure I charge you to court. I'm going to take up this case and all of that. That you not go scot-free with this and all of that. So plus the intervention of the Commissioner of Police and other senior police officers, they were able to resolve it, and the client was granted bail. So we see that in theory, the Constitution as well as other statutory provisions or statutes guarantee the rights of a suspect or anyone who is being called to make a statement, but we see that in practice what actually happens is a different thing. And another thing which I would like to point out is the fact that most of our Nigerian policemen lack very good investigative skills due to poor trainings, and as well as the fact that they are always quick to want to dispose of a case and get it off their head as soon as possible. So all of these things, we want to make them feel that, the best way to get the truth out of this client is always with the use of force. I don't want to know any other thing. You must actually tell me what I want to hear, rather than taking out time and, undergoing. And I think the government also has a role to play in this, ensuring that our policemen are adequately trained enough, to investigate as they should and investigate properly. So we know that basically in practice, what happens most times is a different ballgame.
Thank you. Can you explain the role or the essence of a lawyer when a statement is made?
Okay, so like I earlier mentioned that a suspect has a right to have his lawyer present at the point of making a statement or even giving a statement at all. So the reason why it is necessary you always insist on having your lawyer present is because of the fact that your lawyer knows. We know that a lot of Nigerians are actually ignorant of the law and ignorant of their basic rights. So it is needed that you have your lawyer present who would advise you on your rights and who would also ensure that there is an adequate, a fair playing ground, or if there is fairness when you are giving your statement. And I also like to mention the fact that I think section 9 subsection 3 of the Administration of Criminal Justice Law, although it relates particularly to making a confessional statement, but this also should apply, states that if a suspect voluntarily or wants to make a statement or admits to his guilt, he has to ensure the statement must be made in writing and must also be recorded via video means or audio visual means, and his legal practitioner must also be present at the point of signing or making that statement at all. So it is necessary that you have your lawyer at hand before making any statement at all, to avoid any issue or any contradiction later on. You making a statement you never wanted to make initially, and then it later bounces back on you, and it could even mar the suspect's case. So it's best to have your legal practitioner inform your legal practitioner first of all before making any statement at all. And it also has a way of making the client at ease. We know that first thing that comes to people's mind when they have to go to the police station to make a statement, they're always apprehensive, frightened, and hey, that doesn't mean I'm going to jail, and all of those things. So it makes them uncomfortable initially. So it's best that you just calm down, try to get someone to contact your lawyer who comes and tries to put you at ease, tells you of your rights and helps you out.
Now, on the issue of force, coercion, and duress, what's the implication of the law in relation to that?
Okay, on the issue of use of threats, use of force or coercion while making a statement, well, the law actually does not, would I say the law does not explicitly, the Constitution rather does not explicitly say that you shouldn't, force or all of those things should not be used when making a confessional statement. However, we must note that every human or every person has a right to dignity of persons as guaranteed by the Constitution. Mm-hmm. And like I earlier said, you being a suspect does not make you a criminal, and as such you shouldn't be threatened or shouldn't be subjected to any form of inhumane conditions or treatment. So where the police or any investigating officer makes the use of force, threats, promises in order to force or compel you to make a statement, you need to understand that the statements you make at that point can be a foundation for any charge that will be brought against you in the court of law. So there won't be any charge, you won't be charged to the court if you do not make any statement at all, because there is nothing to fall back on that you actually, there's no evidence, so to say, to show that something happened or a crime has been committed or that you are an alleged culprit, so to say. So it is best that you try to, like I earlier said, you get your lawyer involved, because that is even why the statutory provisions which I earlier cited, try to protect a suspect when he's making a statement. The reason why you need to have your lawyer present, so that the statement you are making would be made voluntarily. It's not something that someone forced you to make or tricked you into making it. So that is why it is very crucial and important that your lawyer is there. And at the same time, I also like to mention that in the event that out of compulsion or out of fear of being beaten or out of even being beaten and threatened or hit, you made a statement. Now when you're being charged to court at the point of trial, either the accused, because a suspect once he's charged to court once he's arraigned becomes an accused person. So at the point of trial, either the accused person or his lawyer has to make a defense or has to rebut the fact that he made that statement, and that is where you are actually questioning the voluntariness of making that statement. So at that point, what the court would do, the court would either would have to conduct a trial within trial. That's more like a small trial within the main trial to ascertain that that statement was indeed made voluntarily. And you could also check up the Evidence Act. I think Section 29 of the Evidence Act explicitly talks about making a confessional statement or the voluntariness of his confessional statement.
Still explaining this point, what do you think can be done where a statement is made with force or where the due process of the law as provided is not followed? What can be done?
Okay, where such is the case and such a person has been charged to court based on that statement which he has made, like I earlier talked about, at the point of trial, the counsel, the lawyer of the accused person or the accused person has to, rebut the voluntariness of that statement.
What should be the ideal thing where the suspect is an illiterate? Because the decision whereby the inspector doesn't understand. Okay, the inspector speaks English and the suspect doesn't understand English. What is the implication of the law as regards illiterate?
Okay, so where the suspect in question is an illiterate in the sense that he does not understand or speak English language and is asked to make a statement, I'd like to refer us to Section 17, subsection 3 of the Administration of Criminal Justice Act, which actually says that where a suspect has to make a statement or make a statement and he does not understand, does not speak, or does not write in the English language, an interpreter has to be provided for him. And what the interpreter will do is to read out the statement and ensure that the illiterate or the suspect understands fully what is being levied against him or what is being alleged to have committed. And having done that, he has to record the statement, and having recorded, the suspect or the illiterate has to endorse the statement, and the interpreter also has to attest to that statement. And so I would also like to mention that at the point of trial, if such statement is being used in trial, the prosecution would have to invite the interpreter who recorded and who explained and recorded the statement to the suspect, would have to be called as a witness. And where such a person is dead or maybe he can't be found and all, the onus will still fall, that is, the burden will still fall on the prosecution to actually lay proper foundation as to maybe the death or that it can't be found. But an interpreter must always be provided.
On the writing of a statement, does the statement have to be lengthy? Because in the cases whereby suspects believe that the more they write, the more the case is considered, and also like most times they will end up collecting extra sheets. So does the statement have to be lengthy?
Okay. The more, there's a very popular joke my lecturer back then in law school used to crack. He said, the more you keep writing and collecting extra sheets, the more you find your way to Golgotha. Anyway, basically, it is best to always keep it brief and simple. Try as much as possible to avoid extraneous issues or extraneous things, and that is why it is very important at the point of being invited to make a statement. It is very crucial that you know the reason for which you are being called. That is, you need to know the nature of the offense that you've been alleged to have committed, so that way it would help you know what exactly you are putting down. Not that you don't know the reason why they even brought you in the first place. Maybe someone made a complaint that you stole his chicken, and then you come and then be like, I was just going on my own, and the only thing that I remember doing was that someone's money fell down and I just picked it up, and instead of giving it to you, I actually just kept it back in my pocket and all of that. That way you're actually self-incriminating yourself. you are adding something else to what was initially or even alleged that you have committed. So it is best that you always know, that the suspect rather knows the reason why he's being invited to make a statement. So that way you would, it would constrain how much or what you say. And you need to know that you being called to make a statement does not mean it has to be as long as you have to give full explanation of everything that has happened, talk about your children, talk about all of that. No, you need to go straight to the point. Keep it brief and simple. Just state what actually happened from your own end, or your version of the narration of the events that led to your arrest. And you can also talk about the relationship you had with the person who made the complaint, and just keep it as brief and as simple as possible.
What are your final words?
Okay, my final words in closing is that, like I earlier first mentioned, it is important that you know that you making a statement or being invited as a suspect to make a statement does not make you a criminal at all. Neither does it make you an ex-convict. So it is best and advisable that you have your lawyer present with you before you make any statement at all, before you sign or sign any statement at all. And it is also best that you remain silent until you have actually conferred with your lawyer before giving any statement to the police, and also know the reason for which you are brought to make that statement. It is your right to know. It is your right to have a legal representation. It is your right to you have a right to human dignity of persons. So you need to understand and know your basic rights. And also, in closing, I think I failed to mention that when a suspect makes a statement, in practice, what is usually being done is that statement is also taken to a superior police officer to endorse such statements, so that at that point you are able to either deny or retract that statement, that, oh no, it's not me that signed this statement when I was making it, or that this statement they forced me to make it, or that it's not my recording. Maybe the police officer recorded it and said I should sign. So at that point you also have the opportunity to retract your statements. So thank you very much.
Thank you very much, Doro. So glad to have you here. Thanks to our viewers. Thanks for joining us. Thanks for watching. Also, don't forget to like our videos. Don't forget to subscribe to our channels. Thank you.